Mr. Hegde, if I could start with you today, in the Munawar Faruqi bail case in particular, uh, your your observations to start with as far as the rejection of the bail pleas for Munawar Faruqi and Nalini Yadav are concerned.
Well, it is disturbing to say the least. And especially with regard to Nalin Yadav, there seems to be no kind of discussion as to why bail has been denied. The everything which the judgment deals with only pertains to Munawar Faruqi, and that too for nothing that he said on that particular occasion. Things which are allegedly said by him on video much earlier. Now, uh, when you sit in judgment over a bail order, you basically check only 2 or 3 things. Will the man be available in case there is a trial? Is there a possibility that he will flee justice, or is he likely to tamper with witnesses? None of those things were also discussed. Ultimately, it does seem to me, with respect to the judge, that the judge was judging the person rather than the case.
But sir, I mean, a lot of course, there are comparisons that are being made to the Arnab Goswami case. Would you say it's a fair comparison to make and a disturbing, in fact, pattern to see that perhaps bail premises are being different, for different people depending on who you are or what your identity is, or do you think it's an unfair comparison here?
Well, it's not an unfair comparison. And sometimes it's also, I think, seeing it as a legal realist, it not only depends on who you are, it also depends on who the judge is. Certain judges seem to have a much greater faith in the freedom of speech, and certain judges seem to think that freedom of speech exists only with restrictions, and one must always be mindful of the restrictions. So if the restrictions eat up the right, so be it.
But the so many activists from the Elgar Parishad case, the Bhima Koregaon case, there are senior elderly people who have been languishing in jails for so many months, and their bail applications have not come through, or their bail pleas have not come through, or they've been rejected. Is there a serious need? That's the a need of the hour to rethink into where are the bail reforms headed, or are there any parameters that one needs to follow when it comes to these bail applications?
Somebody very wisely said that the essence of tyranny is to make harsh laws and then to apply them selectively. So here are very harsh laws like the UAPA, which have been invoked in the Bhima Koregaon case. Now, unfortunately, our judges and even there's a Supreme Court judgment, which now almost makes bail impossible in a UAPA case without a trial actually having happened. At the end of the trial, the prosecution may not be able to prove the man's or woman's guilt. But in the meanwhile, the person will have possibly undergone imprisonment for much more than the actual imprisonment that could have been inflicted. There is something radically wrong, both with the legislation as well as the manner in which it is utilized. Unfortunately, till the judiciary returns to being a sentinel on the qui vive, zealous in the defense of the fundamental rights of the citizen when faced with state excess, we are not going to be a republic of independent men and women.
But why is it not happening, sir, this course correction?
Well, there are people with larger memories than mine. And if I were to quote Mr. Falinaraman, who long ago told me that, majority government will see a conformist judiciary. He's given an excellent example in his book of what happened during the emergency years. Before the emergency, he was an additional Solicitor General for the government. In that capacity, when he was defending the government's action uh, in arresting people, the court was well on his throat, saying that freedom comes first, the liberty of the citizen is paramount. Emergency was declared. He resigned as additional Solicitor General, came on the private side. There was a certain municipal election in Bombay where certain people who had to vote were under detention. He moved a bail application. Then he just couldn't get the bail through. And so, in a sense, when there is a strong authoritarian government, twice I think the judiciary has not really proved to be a check against authoritarianism, has not stood up to authoritarianism.
Okay, that's a very, in fact, a stark reminder of things, sir. But you mentioned Mr. Fali Nariman, and that also brings me to my next question. In the case of the Tandav, the web series, where we just saw in the Supreme Court, the makers and the actors, in fact, they have been appealing for protection against arrest, but they have failed to get any sort of relief from the Supreme Court, and there are multiple FIRs. Now, what is baffling is that in the case of another journalist, Nupur J. Sharma, who also had the court granted an ex parte stay on multiple FIRs against the Op India editor then. Also in the case of Amish Devgan, there were multiple, in fact, cases that had been filed, multiple FIRs filed. In the case of Arnab Goswami, the court had said that it constituted an abuse of process and had a stifling effect on the exercise of freedom and expression, referring to the process of multiple FIRs. So what happens when it comes to, how is it different then when it comes to the case of the Tandav makers?
I don't see the difference, but the judges seem to have. And as I told you that sometimes the Supreme Court being a polyvocal court, in as much as there are different benches of the Supreme Court, one bench may not view it with the same fervor that another bench does. I do think that this is an anomaly which the judges themselves should resolve. Please sit together over tea in a conference and decide that these are the matters where we are all going to grant bail, or these are the matters where we all are not going to grant bail. Certainty is a feature of the rule of law. If you ask me, in such a matter, what do you think a court is likely to rule? I, as a senior advocate, must be able to advise clients with reasonable certainty. These days, very often lawyers have to say, okay, let's fly a kite and see where it goes.
Right. Okay. So there are also perhaps about trial balloons that you're talking about?
All kinds of balloons, kites, whatever. They ultimately, there's an old saying in English law that equity is the length of the chancellor's foot. So we can only hope to appear before chancellors with large feet and large hearts.
Okay. Just the last two questions then, again, staying on with the Tandav case, Mr. Hegde. I mean, in the Arnab Goswami case, if the Supreme Court says that if you don't want to see his channel, don't see. In the Tandav case, what is being talked about is freedom of speech is not absolute. So shouldn't there be that premise apply here also, that you don't see a movie that is offered on your web content?
With deep respect to the Supreme Court and the bench that said it, I would like to quote Chief Justice Ranjan Gogoi in the R.N. Ramnath Goenka lecture that he gave, where he quoted George Orwell, where he said, Orwell says that freedom is freedom to say 2 + 2 makes 4. If that is allowed, all else follows. Today, we are being constantly told that don't say 2 + 2 is 4, but be conscious that you don't hurt somebody's sentiments, that you don't hurt friendly relations, please look at all the restrictions that there are on freedom of speech in the Constitution, and then decide whether you want to speak. There is certainly a chilling effect on speech. Now, if you permit me, I just want to take a little bit of time.
Sure, sir. Please.
To explain in where all these hurt religious sentiments comes from. You know, this 295A was amended in the Indian Penal Code to provide for such things. In the context of an old case from Lahore, where there was a publisher who published a pamphlet with regard to the Prophet called Rangila Rasul. And then there was a carpenter called Ghaziuddin who stabbed, he could not find the author, he stabbed the publisher. Mahashay Ramdas or something, that was his name. So when Ghaziuddin was being buried, there was a huge funeral procession, including Allama Iqbal and one Dr. Deen Muhammad Tasir, who was also a very famous Urdu poet. And they said, some of them said that, look, what this boy has done, we men of learning could not have done, etc., etc. He was made out to be a great martyr, and therefore to prevent such kind of outrage, this particular section was amended. M.A. Jinnah, as a lawyer, warned that the section could be misapplied. And he says that, you know, people who are genuinely researching into religion and all that, they must be protected. Nevertheless, that section came in a colonial administration, which really did not care too much about freedom of speech, but did care about keeping the peace. That section and variants of that have inflicted the Common Penal Code of India and Pakistan. And to complete the story of Dr. Deen Muhammad Tasir, it was his son, Salman Tasir, who ultimately got shot in Punjab because somebody thought that he was blasphemous. When you start fiddling with freedom of speech, when you start saying that, you know, we have the right to censor what another person thinks or says, are down a slippery slope. And one last thing I'd like to say is that he who says nothing stupid will never say anything profound.
Right.
It is of all kinds of speech that human progress happens. Can't shut our minds. We should not allow our minds to be shut down like this.
Okay. Finally, sir, the cost of everything that is then happening. I mean, the Supreme Court, which has talked about civil liberties in the past, upholding personal liberties in the past as well. I mean, in the case of a bail application, clearly, you know, where jail should be an exception, that's completely been put on the back burner in so many cases.
Yes, because ultimately, a bail is one of those little things of discretion, and it often appeals to a judge's general sense of justice, or what he perceives as justice, and which is often influenced by his social milieu, his life experiences. So we seem to have, if I were to put it delicately, a set of very people who are judges who have been very obedient children in the past.
Okay. And that's very disturbing to hear as well. Appreciate you joining us here on People's Editor, Mr. Sanjay Hegde, and clearly, you know, to quote George Orwell again, I mean, to say that all animals are equal, some more equal than others, that should not definitely be the case when it comes to justice, the eyes of the law. And let's hope that, you know, we find ways to course correct here, because things as of now are looking pretty dark. But appreciate you, Mr. Sanjay Hegde, Senior Advocate.